The Fifth Amendment to the United States Constitution is part of the Bill of Rights and protects a person against being compelled to be a witness against himself or herself in a criminal case. Pleading the Fifth is a colloquial term for invoking the privilege that allows a witness to decline to answer questions where the answers might incriminate him or her, and generally without having to suffer a penalty for asserting the privilege. A defendant cannot be compelled to become a witness at his or her own trial. If, however, he or she should choose to testify, he or she is not entitled to the privilege, and inferences can be drawn from a refusal to answer a question during cross-examination. The amendment requires that felonies be tried only upon indictment by a grand jury. Federal grand juries can force people to take the witness stand, but defendants in those proceedings have Fifth Amendment privilege until they choose to answer any question. To claim the privilege for failure to answer when being interviewed by police, the interviewee must have explicitly invoked their constitutional right when declining to answer questions. The amendment's double jeopardy clause provides the right to be tried only once in federal court for the same offense. The amendment also has a due process clause as well as an implied equal protection requirement. Finally, the amendment requires that the power of eminent domain be coupled with just compensation for those whose property is taken. Text: no person shall be held to answer for a capital, or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property, without due process of law, nor shall private property be taken for public use, without just compensation. Infamous crime. Whether a crime is infamous is determined by the nature of the punishment that may be imposed, not the punishment that is actually imposed. However, crimes punishable by death must be tried upon indictments. The historical origin of infamous crime comes from the infamia, a punishment under Roman law by which a citizen was deprived his citizenship. In United States v. Moreland, 258 U.S. 433, the Supreme Court held that incarceration in a prison or penitentiary, as opposed to a correction or reformation house, attaches infamy to a crime. In Macon v. United States, 117 U.S. 348, the Supreme Court judged that infamous crimes are thus, in the most explicit words, defined to be those punishable by imprisonment in the penitentiary, while it later in Green v. United States 356 U.S. 165, stated that imprisonment in a penitentiary can be imposed only if a crime is subject to imprisonment exceeding 1 year. Therefore, an infamous crime is one that is punished by imprisonment for over 1 year. Susan Brown, a former defense attorney and professor of law at the University of Dayton School of Law, concluded, since this is essentially the definition of a felony, infamous crimes translate as felonies. Grand jury. The grand jury is a pre-constitutional common law institution, and a constitutional fixture in its own right, exclusively embracing common law. The process applies to the states to the extent that the states have incorporated grand juries and/or common law. Most states have an alternative civil process. Although state systems of criminal procedure differ greatly among themselves, the grand jury is similarly guaranteed by many state constitutions and plays an important role in fair and effective law enforcement in the overwhelming p. 688 majority of the states. Brandsburg v. Hayes 1972. Grand juries, which return indictments in many criminal cases, are composed of a jury of peers and operate in closed deliberation proceedings. They are given specific instructions regarding the law by the judge. Many constitutional restrictions that apply in court or in other situations do not apply during grand jury proceedings. For example, the exclusionary rule does not apply to certain evidence presented to a grand jury. The exclusionary rule states that evidence obtained in violation of the Fourth, Fifth or Sixth Amendments cannot be introduced in court. Also, an individual does not have the right to have an attorney present in the grand jury room during hearings. An individual would have such a right during questioning by the police while in custody. But an individual testifying before a grand jury is free to leave the grand jury room to consult with his or her attorney outside the room before returning to answer a question. Currently, federal law permits the trial of misdemeanors without indictments. Grand jury indictments may be amended by the prosecution only in limited circumstances. In Ex parte Bain, 121 U.S. 1. The Supreme Court held that the indictment could not be changed at all by the prosecution. United States v. Miller, 471 U.S. 130 partly reversed Ex parte Bain. Now, an indictment's scope may be narrowed by the prosecution. Thus, lesser-included charges may be dropped, but new charges may not be added. The grand jury clause of the Fifth Amendment does not protect those serving in the armed forces, whether during wartime or peacetime. Members of the state militia called up to serve with federal forces are not protected under the clause either. In O'Callaghan v. Parker, 395 U.S. 258, the Supreme Court held that only charges relating to service may be brought against members of the militia without indictments. That decision was overturned in 1987, when the court held that members of the militia in actual service may be tried for any offense without indictments. The grand jury indictment clause of the Fifth Amendment has not been incorporated under the 14th Amendment. This means that the grand jury requirement applies only to felony charges in the federal court system. While many states do employ grand juries, no defendant has a Fifth Amendment right to a grand jury for criminal charges in state court. States are free to abolish grand juries, and many have replaced him with preliminary hearing. Double jeopardy. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. The double jeopardy clause encompasses 4 distinct prohibitions: subsequent prosecution after acquittal, subsequent prosecution after conviction, subsequent prosecution after certain mistrials, and multiple punishment in the same indictment. Jeopardy applies when the jury is impaneled in a jury trial, when the first witness is sworn in during a bench trial, or when a plea is rendered. Prosecution after acquittal. The government is not permitted to appeal or try again after the entry of an acquittal, whether a directed verdict before the case is submitted to the jury, a directed verdict after a deadlocked jury, an appellate reversal for sufficiency, or an implied acquittal via conviction of a lesser-included offense. In addition, the government is barred by collateral estoppel from relitigating against the same defense, a fact necessarily found by the jury in a prior acquittal, even if the jury hung on other counts. This principle does not prevent the government from appealing a pre-trial motion to dismiss or other non-merits dismissal, or a directed verdict after a jury conviction, nor does it prevent the trial judge from entertaining a motion for reconsideration of a directed verdict, if the jurisdiction has so provided by rule or statute. Nor does it prevent the government from retrying the defendant after an appellate reversal other than for sufficiency, including habeas, or 13th juror appellate reversals notwithstanding sufficiency on the principle that jeopardy has not terminated. There is also an exception for judicial bribery in a bench trial. Multiple punishment, including prosecution after conviction. In Blockberger v. United States, the Supreme Court announced the following test: The government may separately try and punish the defendant for two crimes if each crime contains an element that the other does not. Blockburger is the default rule, unless the legislatively intends to depart. For example, continuing criminal enterprise may be punished separately from its predicates, as can conspiracy. The Blockburger test, originally developed in the multiple punishments context, is also the test for prosecution after conviction. In Grady v. Corbin, the court held that a double jeopardy violation could lie even where the Blockburger test was not satisfied. But Grady was overruled in United States v. Dixon. Prosecution after mistrial. The rule for mistrials depends upon who sought the mistrial. If the defendant moves for a mistrial, there is no bar to retrial, unless the prosecutor acted in bad faith, i.e., goaded the defendant into moving for a mistrial because the government specifically wanted a mistrial. If the prosecutor moves for a mistrial, there is no bar to retrial if the trial judge finds manifest necessity for granting the mistrial. The same standard governs mistrials granted sua sponte.